So thank you for the opportunity to present this research here. Today I want to talk to you about analyzing political judiciary during the corporate state using a mixed methodology that combines qualitative contextualization and quantitative and computational methods. And in the following, we use a structural network approach that utilizes networks as epistemic tools. I want to start here. With the fundamental underlying research questions, which is, was there a political judiciary in the corporate state? More specifically, which structures of political judiciary were evident in both provincial courts in Vienna in 1935, and was there differences in how the political opposition was prosecuted? So which factors did actually facilitate a conviction? Was there biases against political orientations, namely social democrats, communists, and national socialists? And can we explain a conviction based on this political orientation of the defendant? And maybe also observe charges that are used for particular political groups, and maybe also specializations of judges on specific groups. So the structure of this talk is as follows. So first I will give a short definition of what is actually political judiciary, then the context of the political system of the corporate state. I will discuss our source bases and the different approaches and analyses we proceeded into. So we operationalized political judiciary according to the concepts of Otto Kirchheimer, which introduces political judiciary as the political reasoning to prosecute. So basically the use of judicial procedures for political argumentation. So, and we complemented this concept by Ernst Frankel's political lawsuit, who stresses the weaponization of the law against specific groups and the disadvantages interpretation of law for political partisanship. In this talk, we focus on these both in red highlighted concepts of biases against political oppositions and of specialized charges. So the system of the corporate state used to be a democracy until March 1933, when Chancellor Dollfuss overthrew parliament due to a lack of a quorum and the resignation of all three parliamentary presidents, and subsequently forcefully denied the regathering of parliament with the use of police force. Successively, Engelbert Dollfuss, the then elected chancellor, and his minister of justice, Cooccurring, established an autocratic regime using emergency decrees. One of the first parts of this emergency decrees was to dissolve the constitutional court, which would be able to object to the emergency decrees, and to impose lots of different legislature on the parliament, who was not able to decide anymore. So among which is the repression of civil rights, which is, includes the right to gather and to strike, which were forbidden henceforward, and also the introduction of a preventive censorship, as well as the reformation of the criminal law, like introducing a martial law, death penalty, double jeopardy, which used to be unconstitutional before, and preventive detainment in the so-called Anhaltelager. One of the first acts of this autocratic regime was to ban the political opposition, starting with the Communist Party in March 1933, and followed by, in February 1934, by the Social Democratic Party, but only retroactively after civil unrests in early February 1934 erupted against the regime in order to take control. The National Socialist Party was only forbidden in July 1934 after the successful assassination by National Socialist members of Engelbert Dollfuss, and resulted in Dollfuss being succeeded by his Minister of Justice, Schuschnigg. Schuschnigg basically introduced purification of the judicial system. He introduced oath of loyalty of the judges on the regime, removed the non-transferability, which of judges, which is one of the safeguards of an independent judiciary, in order to make them dependent on the state, brought disagreeing judges into early retirement, and tightened control on the judicative. And we now look at so you already realize lots of the situation of the law basically already fits lots of requisites of political judiciary. What we look now for is how was actually the legal practice, how was the penal practice inside the courts, how did it translate from the law given like from above within these courts. So the following case studies based on political trials proceeded at the provincial courts of Vienna I and II. The only difference between these courts was that they are divided, the city of Vienna, into different sections, and they were only responsible for their respective ones. We look at these court records from the consolidated phase of the regime in 1935, after the civil unrests have already been defeated, which have been happening in 1934, and the legal changes in order to increase pressure on the system has already been implemented. So this is one of the few years that were kind of calm and business as usual within the regime. Before, as you might know, in 1938, the Dollfuss-Schuschnigg regime basically was abolished with the German Anschluss to the German Reich in 1938. Our dataset involves over 1,800 cases of political charges against over 1,500 defendants, which have been identified by a research project at the University of Vienna on political repression. I want to note here that out of these cases and defendants, like 91% of those can be identified to belong either to the Communist, Social Democratic, or National Socialists group. So the majority of these defendants, we know their political orientations of. Usually court documents are used as a source for the social history of criminality and the development of penal practice. What we want to use these court records for is to structurally analyze legal practice with the means of a network approach. We have to note here, court records are a very peculiar type of source because they represent the perspective of the courts on the defendants. And Schwerhoff, for example, therefore called these court records involuntarily ego documents. So we have to keep this in mind. This is simply the perspective of the courts on the supposed offenses of the defendants. If we operationalize court records as networks, there are many ways to do so. You find here an example of focusing on simply one defendant only here on the right side as part of this case in the lower part, in the upper part. This case is based on a defendant. It gives you the overview of the main points on this trial. The defendant here is a 20-year-old metal worker who was accused of forbidden gathering, of discrimination against the administration and the societal values of the corporate state, and of spreading rumors, among other charges. He was then subjected to a trial and convicted of the discrimination charges and imprisoned for a year until June 1936. This case, this individual case, was already actually part of a bigger group case of 15 other defendants who had each individually charged tailored charges. So here we have to you can easily lose yourself into in these multimodal networks. Therefore, you have to have a focused perspective. our conceptualization here is basically that of network as epistemic tools and networks as models. In the classical definition of models are based on Stachowiak of 1973, that models are basically an approximation of reality through the subjective selection and weighting of important and or representative factors. As such, models can be coined epistemic tools, which follow the famous dictus of Stachowiak with that everything is an insight. So every insight is an insight through models or in models, following which Lemoyne coined very pointedly as we model to understand. As a consequence, any model, or this is more of a caveat, any model is only one instance of all potential models and offers only an approximation, but never the truth if it as though exists. Network as models follow the very similar definition of the general model as a focus on a perspective on heterogeneous relations between entities, and thus offer a reduced complexity through the selection and representation of factors, and therefore an approximation of reality, but again, only one implementation of like a potentially endless number of different models. As such, we can use these networks as tools, basically, with an underlying subjective selection process, which means that we can both reject them and adapt them. And actually, we are supposed to do so. Historical network research basically allows us to do a structural analysis of networks instead of simply using them metaphorically, and do a semi-automated analysis of historical big data. Semi, of course, because it's not fully automated, as it still requires a careful investigation and an individual coding to fit the requirements of the data more closely. Oops. We argue here that these methods are complementary, so both the quantitative and the qualitative, instead of having a competition or a divide, but still require like a careful analysis of inherent fuzzy historical sources. After all, the fundamental goal of historical network research is to further historical knowledge and to fill in gaps of research, as in this context on the corporate state and its penal practice and the structures in court, and allow to falsify claims of qualitative scholarship. So this requires both the knowledge on computational methodology and coding in order to counteract a black box of automation and to know what's going on there exactly, and the traditional hermeneutics of the historical toolbox and their contextualizations. So if we go back now to our initial question, so which factors did facilitate a conviction, and what kind of biases are at play at the political orientations? We looked for these biases in a quantitative approach in how whether a trial was opened or not, so whether a prosecution preceded the initial inquiries of the police. And here we can see that in the right-wing groups and the left-wing groups, they are first of all of very similar sizes, and they get prosecuted in very similar numbers. Around 60% don't get prosecuted at all in both groups, and roughly 40% lead to a trial. If you look for the trial numbers, convictions happening in almost 90% in both groups. So this is a very, very similar prosecution rate. And it's not shown here, but if a conviction was achieved in both left and right-wing groups, we have almost 100% imprisonment rate. So if we look into the of sentences, we see stark differences in the sentence length. So if you compare here the right wing and the left wing groups, we have an average difference of 150 days of an imprisonment sentence length. So now, if we look now for the distribution of these sentence lengths seen here, it becomes quite clear that up to close to a 1 year mark, both for National Socialists and left-wing groups, the imprisonment rates were very similar, and that the National Socialists are missing the extreme sentence lengths of up to 10 years that communists, for example, have here. So we have to ask ourselves, so why is this? Why is these stark differences in the sentence lengths? And this leads us to the question, so what are these two groups actually charged of? So why do we observe these differences in the sentence lengths? So in order to give you a little bit a background to the process inside these trials, so first you have the inquiries by the police, followed by possibly the admission to trial in the charges, which, as we've seen, happens in around 40% of cases. And then in the final part, if there's a verdict of a sentence, or like in a conviction or in an acquittal, we have the delicts of conviction that the judges provide in the final step. So we looked for the kind of offenses that were charged in each step. Therefore, we investigated networks of co-occurring offenses, which, if you may, share kind of fingerprint properties of each political group. An interesting development and evolution of these charges is, so you have here also the National Socialists, followed by the Communists and Social Democrats, and in the y-axis, the first inquiries, then the charges, then the delicts of convictions. And you see for National Socialists, there's an above average combination of charges of both gossips and the membership of an illegal organization, which is usually the banned National Socialist Party. Followed by, in the delicts of conviction, a very high percentage of mitigation of punishment, and in combination with the secret organization membership accusation in the verdicts. Whereas members of the Communist Party were most often investigated for public disruption and secret organization membership, as well as high treason in combination with Aufwiegelung and Agitation, which are basically disrupting the public peace with either violent and non-violent intentions, and were most often convicted for public disruption and anti-state printed works. Social Democrats in the lowest part here were most prominently accused of high treason and deception, as well as public disruption and gossip, but there are no real peculiarities for them in the verdicts. So if we focus now on the differences in the sentence length, we can see that the high treason charges for National Socialists and Communists, which were originally very evenly distributed in the inquiries of the police, suddenly were dropped for the National Socialists in the verdicts, and replaced by accusations of secret organization memberships, thus resulting in much more lenient convictions in the verdicts, in contrast to, for example, communists who actually were sentenced because of these initial inquiries of high treason. Therefore, we can conclude for a relative leniency of against leniency for right-wing groups in contrast to left-wing groups. Then we investigated structural predispositions. So are there specializations of judges, for example, against specific political groups? So here in this graph, an edge equals conviction. The character of networks as epistemic tools becomes here very clear in this line of investigation, because here you might think that this node with the highest degree centrality, a judge, actually the vice president of the provincial courts, would have been specialized mainly on left-wing groups, or this one here on social democrats, or this one here on communists, or these two on national socialists. But actually a close reading of the sources reveals that this would not be correct, as these individual cases belong to bigger group cases or group processes, and therefore you don't really see anymore a specialization of a judge on a specific political orientation, but instead you have these group processes that are basically characterized by the accusation of a group, a homogeneous group of political orientations. We looked for cooperations of judges with prosecutors and analyzed the harshness of the sentences. So, for example, here you see we normalize the proportionality of sentences due to the upper and lower bounds, which is given in the penal law. And mapped these to the cooperating judges, which allowed us to identify two groups of very harshly acting judges and prosecutors combinations. Interesting though, the already mentioned vice president of the provincial courts, Osio, who's also indicated here on this graph, who is known in the transmission as being a very harsh judge, actually doesn't appear here to be overly severe in the sentences. We did a clustering run on these judges and prosecutors cooperations in order to identify different groups they belong to, which ultimately showed two main clusters indicated in different colors, which iterated again their activeness at these both provincial courts of Vienna I and II. So in order to let me conclude here at this point, studying court records as network models offer the utilization for structural analysis, and this revealed different specialized strategies in prosecution and sentencing of the political opposition in Vienna during 1935. A close contextualization, however, and reading of sources revealed that there are no individual specializations on specific groups, at least up to what we know today. The so-called Geschäftsverteilung, the executive organization charge, is still missing for 1935. If this would be available, we might be able to make some more inferences on specializations there. But we also found evidence for agency within the police and the prosecution and the judges, despite its centralized coordination and the purification of the system during the Dolphus-Schuschnigg regime, which became evident in these specialized charges that basically changed from the level of inquiries of the police to the prosecution of the prosecutors and the delicts of conviction of the judges themselves. The conjoinment of qualitative and quantitative methodology offers new perspective on the question of political judiciary during the consolidated phase of the corporate state. And we could, in the process of this project, refine various assumptions of qualitative scholarship on penal practice, including the prominence of high treasonous charges and the severity of sentences. The limitations, of course, as when working with any historical source, is basically the fuzziness and fragmentation of sources. Therefore, any conclusion can remain only to the best of our knowledge. However, following the high number of cases helps to properly represent real-world phenomena following the concept of, or the law of big numbers. After all, I think it's pivotal that a critical historical hermeneutics combines the analog and the digital, which involves the combination of the qualitative and quantitative and computational approaches. I'm happy to discuss this here in the following, and I want to point to this talk, which is based on the paper published recently in Social Networks, and want to thank you for your attention.